If you were not a lawyer, what you would be?
No, I think, as I told you, I was a reluctant lawyer.
Yes.
And my background, I told you, was service background. My father was a police officer. I don't know what I could have done. I can't tell you that today. But yes, being in this profession has helped me to use my time in various activities. Because apart from doing cases in the court, spending time, the whole week almost goes there. Every Sunday, people think Sunday is a holiday, but for lawyers, Sunday is not a holiday. We start working in the afternoon, and then Monday, Tuesday, Wednesday, Thursday.
We have cases.
Yes, up to Friday. Then we have Saturday, Friday afternoon onwards on Friday, and it's not definite all the time. It's changing. So you have to manage yourself. If you manage, you can do little bit of everything. But I mean, you can say that I'm a rolling stone, and I gather no mass.
Good evening, ladies and gentlemen. I am Ajay Veer Singh, and on behalf of the Indian Advocate Forum, I welcome you all to our episode on prominent lawyers in this country. I'll today introduce you to Mr. Rajiv Dutta, who's a senior advocate in the Supreme Court, and he has just completed 5 decades of his practice in the Supreme Court. In this episode, I want to give you an insight into the life of Mr. Dutta so that we all get inspired by what he has done in his life, what he has contributed to the legal system and to the entire justice delivery system. He has been a reluctant lawyer. And after being a reluctant lawyer, a first-generation lawyer, he has made up his mark in the Supreme Court. He was elected as Vice President of the Supreme Court Bar Association. He got designated as Senior Advocate in 2000, yes. And the list is endless. His achievements have been there. And whenever we talk to him, he has so much to share with us. And I welcome you all to a chat with Mr. Dutta. Sir, you're welcome on the show.
Thank you, Ajay Veer. First of all, let me thank you for having me on your show. And it's a great honor and a pleasure. And yes, you rightly mentioned that I was a reluctant lawyer. And you also mentioned that I'm a first-generation lawyer. And probably that was the reason why I was reluctant to join the profession. Because my background, my father was a police officer, service background basically. So for any person who's brought up in that background to come into a profession which is as independent and with all the things attached to it, it's very difficult. So probably first generation lawyer does have a problem in getting into the profession.
Now, on the other side, do you think the first generation lawyers have an edge over the second generation and third generation lawyers? Some advantage? They have a clean slate to start with?
I see, you can't measure up these things very, like mathematically you can't do it. But I think both ways, it works both ways.
So you said that first generation lawyers have some kind of disadvantage. On the other hand, if we talk to some second generation lawyers and third generation lawyers, they are of the view that the first generation lawyers have an advantage because they have a clean slate to begin with.
I think you cannot definitely say which one has more advantages or disadvantages. But yes, there are some very obvious things. For example, if you come from a family of lawyers, the first thing that comes to mind is then there is a lot of burden on your shoulders. Being born in a family which is of successful lawyers, so you have to carry that burden ahead. Similarly, I think you do get advantage over others in getting some good work. But then again, it is at very initial stages that you may be getting work because you belong to a certain family.
Isn't it true that nothing grows under the banyan tree?
Yeah, well, it's yes, those are all catchy phrases, but yes, but sometimes the people who work under the banyan trees also have a lot of advantages, So one of the most important things in our profession is to be recognized to get work. Now, those who start off from the scratch, they have that initial disadvantage. So basically, it depends on where you start your work or in which company you fall in. I mean, if you work for a law firm or if you work with a very good individual lawyer, and it then becomes a kind of platform for you. That's how you get recognized. Because to get independent work, it's very important that people recognize you. Not only people who are in litigation or otherwise demand some sort of resolution on law, but otherwise also, even in the profession, to get recognition in your the courts where you practice, whether it is Supreme Court or High Court, how much recognition you get from the bar is very important, and that is time consuming. It can never happen overnight. And when you said that somebody comes from a background, I think they may have a little disadvantage because they are already known for what background they come from. So starting from a clean slate that way may be good. But yes, law as a profession for both who start as with a background or otherwise, according to me, hard work and nothing else. As they say in music, it is practice, practice, practice. In law, it is hard work, hard work, hard work.
Now, in this background, I have a request to you. Can you have a piece of advice for the first generation lawyers?
Ajay, let me firstly make a little correction here. I will be completing 50 years in practice in the month of December. This December 2025. And a few months are still to go. So the second thing I have to make it very clear is that initially when I joined the profession, I joined with a senior advocate, and I had the great opportunity of accompanying him and going to the High Court and the Supreme Court. But at the same time, I would say I was fortunate to get work and also execute a lot of work in other courts also. So I think when you say that I worked solely in Supreme Court, it may not be that correct, because I initially, for quite a few years, I was working simultaneously. Because you see, when I started my profession in 1975, there were hardly any tribunals. There were no tribunals at all. We had the opportunity of filing fresh cases directly in the High Court, and then, of course, coming to Supreme Court. And one important thing which you are very much aware, that right from 1975, right in 75 when I joined, a rule was introduced in the Supreme Court that you cannot sit in the advocate on record examination in the Supreme Court for 4 years. Before I joined, you could sit in the exam right away. Right away means after joining the profession, in 1 year, you had to take training for 1 year under an advocate on record of 10 years, and you could sit in the exam. But when I joined, they introduced the rule of 4 years. So I had to, that 4 years I could not become advocate on record. I could only sit in 1980. So that is one thing. But yes, I would say that Supreme Court, your question, to answer your question, what Supreme Court was in 1975 and what it is today, there is a sea change. there's a sea change. In the manner in which right from the beginning, because I was an advocate on record for 25 years. And then I was designated a senior. And now I'm going to complete 25 years as a senior advocate. So I have gone full circle, you can say. So starting from the filing of the cases and from getting the cases listed in the court, briefing the senior advocates, and also appearing in the court at the same time, managing everything, was quite different from what it is today. See, one thing which is not to be told, it's common knowledge, number of lawyers have increased tremendously. Secondly, when we came into the profession, we were totally new. We were a novice. First thing you have to learn when you become a lawyer is the procedure part. How the case has to be drafted, how it has to be filed, how do you do the sittings with the clients. And then, of course, arguing in the court may come easily to some, but with some difficulty to others. But today we find things are very, very different. The court has grown in size. Number of judges have increased. So, managing, when I joined the profession, there were only 5 courts. And
the 5 courts in the front row of the Supreme Court.
In the Supreme Court, right? 1, 2, 3, 4, 5.
Yes.
And now you have about 16 courts.
17.
17 now. So this number will keep increasing. That is one thing. To manage for an advocate on record to be present, because it's also a rule in Supreme Court that advocate on record must remain present when the case is being argued. So I think it's become very, very tough for my other colleagues, my brethren, to execute the work like we could do more easily. Secondly, I think there is a sea change also because of the introduction of the technology. With the induction of technology, both things have happened. It has become easier and it has become also difficult. So we got introduced really to technology was when COVID came and we started arguing our cases online. Before that, I don't think many of us had that experience. So, number of cases has increased, number of lawyers have increased, number of judges have increased. Building itself has grown. We could run from one court to the other.
Expansion is there.
Yeah, expansion, infrastructure has grown. All these things. In fact, one of the biggest problems that every lawyer faces in Supreme Court, we are talking of Supreme Court, even in the High Court of Delhi, of which I am very much a part right from the beginning, is parking. I mean, there is when you go in the morning to the court, it's very difficult to find a place to park your car. So I think a lot of things have changed. In fact, now the judges have on a Monday and a Friday, miscellaneous days, about 75 to 80 cases before them. Now, you can imagine to deal with 75 cases is not a mean thing. I mean, it's a very tough thing.
Now, sir, even though you'll complete 50 years in December, I give you this grace of a few months, and I'll treat you as a lawyer with 5 decades of experience. My request to you, rather, with this background of 5 decades is, can you just trace the evolution of the judgments? How you see the judgments? What's the change? We had a certain trend in the 70s and 80s and 90s, and then we came to the 21st century. What is the difference now? How the law has evolved? Which way we are going? I mean, can you trace the broad contours of the judicial mind?
See, it's a very difficult question that you're asking because according to me, the judges have always done complete justice, and I think upholding of the Constitution. Mm-hmm. And when I just joined the profession in 1972, the Keshwananda Bharati judgment came. Mm. So we are that fortunate that there was a clear picture drawn by the court that fundamental rights are basic structure and they have to be protected. So that part of it, and the court has, let me tell you, the constitutional courts, high courts and Supreme Court, have done yeoman service to this country. According to me, each and every judgment of the court is well considered. Judges spend a lot of time on it, and they are upholding the rule of law. That is one very satisfying aspect of the profession. And that way I feel I am very fortunate to become a part of this profession. And the freedom which is expressed in the Constitution in all its articles has been fully upheld by the Supreme Court. Supreme Court is the guardian, and you can approach the Supreme Court directly, you know that under Article 32. It's itself a fundamental right. Yes, there are various times when court now has started shedding a little bit of a load onto the high courts. When we file a 32 petition, the number of petitions filed under 32 are much less now. The court is of the view that you should go to the high court first and then come. But ultimately, Supreme Court has done a great service to the rule of law in this country.
So you are satisfied that Part 3 of the Constitution, the fundamental rights, have been protected well by the court?
Yes, 100%. There is no doubt about that. There is no doubt about it.
So the balance between the three organs has been kept by the court?
That is a different question. See, I'll tell you, we've come through a passage when there were no public interest litigation, for example. It started rather late in 80s, the public interest litigation, and the court stretched the interpretation of Article 21, Article 14, and all that happened only because the meaning which the court wanted to give or put life into the Constitution, that is what it has done. And all those judgments like Maneka Gandhi and other judgments have really brought about a very big relief, only to say in few words, to the citizens of this country.
Sir, but there have been some disturbing events. I'll read out an extract from the speech of Edmund Burke, the British parliamentarian, in the year 1789. An event has happened upon which it is difficult to speak and impossible to be silent. Now, this was on the occasion of the impeachment of Warren Hastings. You may be aware of that. Now, today we are faced, if not the similar situation, but something akin to that. We have two judges who may very soon face the impeachment proceedings in the parliament. Now, in the independent India, I think it has not been very many times that impeachment proceedings started against the judges. If you go on Google and you find out, they say 6 times, but every time, whatever has happened, but nothing happened against the judges, for whatever reasons. I want you to just give your opinion on this. Is it so difficult to remove the judges, especially when there is glaring evidence against them?
Look, I think what you are asking a very obvious question.
There was an article by you, I think, very recently.
Yeah, I wrote an article which is on LinkedIn.
Yes.
It is on my profile in LinkedIn. Basically, I felt that whenever I met people, they were not fully aware of the process of how a judge, when this situation as it emerged now, we are talking about, let's talk about the cash at judge's residence case. So the people were very confused as to how come this happened or that happened. The fire brigade went there, the police went there, and nothing happened. And then how the judge was transferred to the parent high court. So I thought it is very important on our part as lawyers to first explain to everybody as to what is the process. And Article 124 very categorically has defined as to how the impeachment of a judge will happen, and impropriety, and if there is some thing that has happened which will be demeaning the office that he holds. So basically the procedure is very long. You have mentioned the other cases also, that the procedure could not complete for various reasons. But what is important in what you say is also to see that so many years our constitution has worked, and only these few cases that you have mentioned have happened. So that is the good part of it. But otherwise, I think purposely the constitutional makers have made this procedure slightly cumbersome. Because you can't treat a High Court judge, a constitutional appointment, like any other civil servant, or the manner in which the inquiries are held there, and the suspension orders are given, and then ultimately the final order will come. Yes, it is taking time, but I think credit goes a lot to the erstwhile Chief Justice, Justice Sanjeev Khanna, who held it very, very, who handled, not held it, but handled the situation very well. And the inquiry report has now become public also. So according to me, there are debates going on whether that inquiry will stand the test of law. According to me, it is an inquiry which has been conducted by three most eminent judges, chief justices rather, of this country, senior most chief justices, and they have given a very detailed report. I think at least the parliament, when they will be able to now debate, whenever the motion is admitted and the parliament debates, I think they'll have full knowledge of the evidence and the statement of witnesses, etc. So according to me, that report can be treated like a charge sheet. And
it is in a way.
Yes, because it gives all the details, and very painstakingly the judges have spent so much time and given a report. And I think after all, Parliament will only debate it. And of course, now there are opinions floating that Justice Verma should resign, rather than putting the entire judiciary into this discussion in the Parliament. And then after the Parliament committee also, once the debate is over, then it will be sent to the President. And thereafter, the other procedures will start. So I think the procedure is cumbersome, but it is also required that it should be done very, very intensely and not in a hurry. So that is
the other case in which a judge gave a speech in a public meeting, and he spoke something which was not proper. Now, in that case, do you need more evidence?
See, I am not a judge here.
Okay.
I cannot judge whether he should be impeached or not. That will depend on the Parliament's debates. But yes, as a citizen, I feel once the judges have taken the oath on the Constitution, I think there is a Lakshman Rekha in which they should operate. And it is not proper for judges to indulge in, making public speeches like that. So, but still I would say the process is on, the process is going through, and ultimately we'll get the result. So I don't want to be a judge here. It is a very disturbing feature. Every person who is in the profession, including me, we were absolutely, I would say, it's not a question of being put to shame. It's a question of feeling let down rather than anything else. That such a thing could happen, and in today's time, and so blatantly. So my view is very clear that it is not only Justice Verma, there are other people involved, and I hope the ultimate culprits are found, and punished according to law.
Now, sir, in this case, we have seen structurally we have a provision in the Constitution for removal of judges. Now, that has, and now my question is, has that served its purpose?
According to me, I already gave you the answer. Yes, we must have some patience.
So, having discussed about the some flip side of the things, how they are, you have been in AOR for 25 years. Now, sir, given the background that you have been a senior advocate also for 25 years, you have been briefing seniors and now you are getting briefing from the AORs. Do you think that the AOR system is working well for or is conducive to the maintaining the high standards of the apex court?
That's a very good question you've asked. Since I have experienced it, I can give you first-hand answer. I think, according to me, I am in favor of the dual system. I think an advocate on record in Supreme Court is a necessity. Not only rules like that he should be living within 16 kilometers of the Supreme Court, etc. Not that, but I feel an advocate on record is an institution in itself. See, it is something else to think that once you have already qualified as a lawyer, you have already sat in the common test, and then to be tested again. Now, firstly, the test comes after 5 years. And the other thing is that it is very necessary that you not only practice under an advocate on record to learn the procedures and become familiar with it, also you learn the practice and the procedures of the Supreme Court. And giving an exam is absolutely very easy for anybody who has practiced in Supreme Court for 4 years. It is not such a tough exam. Only 4 papers and all related to the working in the Supreme Court. And one of the things which I always emphasize, you see, learning practice and procedure, rules, etc., and drafting, or learning leading cases is all fine. But I think one thing which is now very important, and we feel that it is something which needs to be taken very seriously, is the ethical practice of the advocates, not only AOR but all advocates. There have been instances in the Supreme Court which have led us to believe that we need a little more stringent thoughts or a little more emphasis should be given to ethics, because it's the highest court of the land. And when you say the Supreme Court gives its judgment, Supreme Court gives its judgment only after it gets due assistance from lawyers. And in that, I think the advocate on record system is very good. It should be improved further. And secondly, you asked me a question, how is my experience? And I can tell you, after I was designated as a senior advocate, it's not only that you have put on the silk. I think I learned this from a very eminent senior in the Supreme Court, that silk, that flap on your gown puts extra burden on your shoulders, and you must have the courage to hold that burden. So, as a senior advocate, I think it gives you more experience of diving deep into the matters, and of course, to assist the court in arriving at the correct decisions. The senior advocate's role is also very, very important, and advocates on record have their own arena, and senior advocates also, I think, are necessary, who provide all the assistance to the court. with all their, the time that you spend on the brief now is only on reading and thinking about the matters. Earlier it was on drafting, filing, getting the matters listed. So I think both are very good. Dual system is what I have always liked it.
Now, on the one side, we have the adversarial system. We have cases in the court, they are decided, and then there are judgments which are followed by the junior courts, high courts, and the district courts. There's another area which has developed, and you have contributed a lot to that. That is alternate dispute resolution system. I believe you must be an arbitrator in almost all international arbitration agencies. You are in Singapore, you are in England, you are in DEAC, and there may be many places, but I believe in most of the Commonwealth countries you have been doing arbitral tribunals. We have been an arbitrator, and you are also representing parties in there. So my question to you here is,
your question?
India, people like you who have done so much of hard work in evolving this field of law in India, despite your hard work, why India has not come up as a seat of arbitration in comparison to what we have England and Singapore and even Dubai now? ICA has, I think, have a branch in Dubai also now.
So in comparison, you find India is less.
Why okay. Indian parties are preferring Singapore as a seat of arbitration or England?
I understand this question. It's a very obvious question.
And this is being raised every time we have a conference on arbitration.
Yes, we are always raising this.
This is a big question mark.
I will answer your question in a very different manner. I'll tell you, when I was going through my profession, I found there are 2 or 3 fields of law which just emerged afresh right in front of us. The first one was environment law. It all started in 80s and then it got developed. Then secondly, I saw that there was a lot of emphasis being given to ADR, that is the alternate dispute system that you are talking about, a resolution system. And then something which came up front and I could immediately relate to it was the arena of sports, because even today we don't have a specific sports law or legislation by the parliament on sports. So these 3 fields came as absolutely new, and it gave me a very good opportunity to delve into them. Like, let's begin with arbitration. Now, arbitration law was always there. Earlier when we joined, 1940 Act was there. Then 1996, we amended the law because, globalization, and we wanted to give further emphasis to arbitration in our country, which was, in a state of, there was a status quo kind of a state. And our law was not up to the mark internationally. So we followed the UNCITRAL law model, and we made 1996. Thereafter, there were so many amendments which had to be made, because just by introducing law and not having a practical aspect of it led us into making various amendments. I think India is emerging. I think a lot of investments have come to India, and they will continue to come. India is a developing nation. 4th largest economy in the world. It's not a mean thing. And the thing which is yet to be answered in arbitration field is that for a very long time we have this habit of naming arbitrators as retired judges. I'm not saying retired judges are bad or good, but as arbitrators, after serving, I think it became a kind of a trend which we need to overcome. We need a specific bar. We need people only to be arbitrators. There are a few things which are changing with the development of certain institutions in the country, like Mumbai is doing very well. And we also have India International Arbitration Center now. It is a statutory body. doing very well. But it will take time. We should have patience. The most important thing is that the arbitrators have to now, abroad. I have sat with QCs from abroad. Their approach is based on a very streamlined approach on the basis of the institutions which appoint them. So I think with the advent of institutions in the country, ad hoc arbitration, which is bound to happen, will be confined to domestic arbitration. And I think Singapore did that very well. Singapore is, of course, I always maintain that we should not compare Singapore with India. Singapore is a very small country, and they have very limited problems to deal with, and they could solve them very easily with the help of the government. As far as we are concerned, India is South Asia. India is a continent in itself. So I think slowly I have always been of the view that we should have a domestic arbitration act for the domestic arbitrations and an international arbitration law for the international arbitrations. I think we have part 1, part 2, etc. in the act, but somehow or the other, we need to develop all this more. Lastly, I must tell you on mediation, because I think mediation is one subject which is growing like fire in India. We have ultimately realized that to mediate people and settle their dispute is far more important than taking them through the litigation way. It's not only to lessen the burden of the courts, but I think we have to form the litigants have to understand. And by the time we develop a very good mediation bar, which we are developing very, very well in this country, every high court has a mediation center. Delhi, if you go, Samadhan is doing very well. Nivaran in Supreme Court.
You were the pioneer.
Yes, I was one of the founders of Nivaran in Supreme Court. We are doing extremely well, and I think good response is coming. So mediation is something which is picking up. Even in sports, I always say that we should mediate. Sports law is yet to develop. There are a lot of areas where I think the parliament needs to work on. Bill has already been introduced.
The basic question would be, do we have a law that governs the sports?
Yes, we have. In fact, we have...
or it's at the nascent stage?
No, we have. No, not at nascent stage. At the moment, we have what is called the Sports Code.
Yes.
2011. Till we make an act, it has already been declared by the courts that this should be treated as a law. So the most important thing in sports that we are finding where there is a lot of litigation is in governance. And the issues of who are to manage these federations. We have 52 national federations in India, and we have state associations. And the most important thing that we are lacking is the same people who have been running these federations get re-elected. For years that was happening. Now a lot of things are improving. Delhi High Court has given several judgments. In fact, several judgments from Madras High Court. In fact, now Supreme Court is at the moment considering a constitution for the Athletics Association also, for the Football Association, which has been redrafted by an eminent retired judge of the Supreme Court. That is, so objections were called for it. And lastly, I must tell you on environment. I think environment is something which has grown in our country. The need was always there. We neglected it. And then in 80s, we got thumping judgments from the Supreme Court. The constitutional courts came to the aid. And we developed a lot of law by now. And I have done a lot of work on the Delhi Trees Act. For example, the deconcretization of the trees in Delhi. I filed the petition in 2012 in the NGT, won the case. Secondly, I am doing a lot of work on forest fires in India, Uttarakhand and all other hill states and otherwise also. and on the basis of my petition.
I remember there was your petition in the Supreme Court. So you have been monitoring along with the court. I mean, at the instance of the court, you were monitoring the progress of dealing with the forest fires by the government there. My question is, do you think that we are well equipped to deal with the forest fires in this country?
Yeah, why not? We have done very good work. In fact, recently I have submitted a report to the Supreme Court. After the Uttarakhand fires last year, I filed a petition directly in Supreme Court this time because there was already a SLP pending in which I intervened, and the state of Uttarakhand then for last 1.5 years they have done tremendous work on controlling the fires. See, forest fires is a question which, it's dependent a lot on nature. But our problem was that we were not tackling that problem. We were not able to administer, and we were not able to douse those fires because we were having less equipment, we were having less number of people. Then there were also issues about the funds being diverted to other areas of development. All that has been taken care of. Recently, the court asked me to go to Uttarakhand and also inspect what changes have come about. I have already filed my report. Right after the vacation, that matter will also come up. And on the basis of my petition in NGT on forest fires, which also I filed because of Uttarakhand and Himachal and Jammu Kashmir, I think now in 2018, the Government of India then came out with a national forest policy. Mm-hmm. And that is in 2018. That was after my petition. Now that is in vogue, and I think a lot of work has been done. And if today the weather is good, and if there are less fires, but the question is when the weather goes bad, how are we able to control and manage them? So Uttarakhand, on my inspection, I found they have come out with a very they are using technology now. See, when a forest fire occurs, the satellites immediately tell us where the fire is. But how to go and douse that fire? We must be equipped. We must have the requisite number of men, the equipment, and also the will to go ahead and do it. Because, in mountain terrain, it's very difficult for a person to travel deep into the jungles without being fully equipped. All that is, in the last 1.5 years, a lot of work has been done. And I'm sure in future also they will do it.
So the third arm of the state, the judiciary, is doing what the executive should have done on its own. Now, let's go further. You started your practice when there were typewriters.
Yeah, I still have.
And gradually you had electronic typewriters.
Yeah, we had first electric, then electronic.
Then electric, then electronic. Yeah. And then in the 90s you had the computers.
Yeah, yes.
And now you have something much more than the computers. You have the internet. There are no books now. Everybody is carrying their library and files on the laptop and the
iPads.
So it's all in the cloud now. My question to you is that despite the development of technology, so much is available in the legal arena for us. The pending cases, the numbers are increasing every day. 20 years back, I remember attending a seminar and where the main question was how to deal with 3 crore cases, pending cases. And today we go to a seminar and the question is how to deal with the 4 crore cases. Despite technology, despite the intention and even increasing the number of judges, what we are seeing today is that earlier we used to have the admitted matters coming for hearing in 2, 3 years, 4 years maximum. Today it's 15 years. And high courts, after 40 matters, the high court judge gets up because he has no time for the other matters. So you are not getting a date. In Allahabad High Court, somebody is not getting a bail because his matter is not getting listed. So when we mention this matter, the enigma before the Supreme Court, they say, we can't do anything about the Allahabad High Court. So now this is the kind of helplessness. How do we deal with that? Certainly we all are aware that Allahabad High Court is functioning at half of its strength. And nothing has been done about it.
No, I don't think you are right in saying nothing is being done. They are doing a lot of work on that. But let me tell you, this pendency of the cases, and see, a case is to be analyzed and argued, and there is a certain limitations which apply to a case. Every case is not like an application made and answered, like in a government office. It requires very deep analysis. Now the point is, yes, one of the things which we are doing and which we need to do much more is appoint judges. See, in a country like China, see, our population is almost now crossing China.
We are more now.
For example, in Delhi, we have one judge for 10 lakh people. I mean, I'm giving a very rough figure. People may give a better figure. But we need to increase number of judges, but we also need to increase judges who are eminent, who are more sort of meritorious and hardworking. Infrastructure has improved. You go to Delhi now, you go to district courts. You are talking of Allahabad High Court. I think Allahabad High Court has its own problems which need to be looked into by increasing the number of judges. The bar has grown so much. The number of... See, one thing which comes to my mind immediately is that why do we have more cases today? Because people are becoming more aware of their rights. And that's why we are... So it has to be answered. It has to be the government and the executive, they have to take note of that. And I think by just converting courts into tribunals, it has not worked very well. Half the tribunals in this country today are not fully equipped with number of judges, with less infrastructure. So all that needs to be done from ground level.
Sir, recently there has been a very different kind of development. For the first time, the government of India invited eminent members of parliament, eloquent members of parliament, and they sent them across the world to represent India's cause. For the first time, we learned that these parliamentarians are having the same view as far as India is concerned. They defended India's stance vis-a-vis Pakistan everywhere, all over the world, and they were from opposition. I mean, this is a new development I have seen.
I don't think if anybody has an impression that the opposition parties are there to oppose even when the sovereignty of India is in danger. I think they are all working in unison, and even the opposition parties, just because they have not been elected and they could not form the government doesn't mean that they are against the sovereignty of India. So I think one aspect of it was that it is a very good move by the government, and I think it shows the unity of India. It has, and a lot of debate is happening on this. But according to me, I think it was a very, very good move to go and make some nations, some countries aware of what we are going through. And I think that has to be done by the parliamentarians and parliamentarians from all sections, all parties. I think it was a very, very good move. And how much we gain from it is another matter, but the point is the effort is there.
How do you manage your existence as a lawyer? Fine arts, I mean.
Yeah, I do some paintings also sometimes. I do paint, and a few things I have painted. I've always been a little bit of an artist. In my even childhood, I used to draw. And I do a lot of things which are different.
I'm really inquisitive to know, how do you manage to play the piano or the saxophone and sing and doing all these things at the same time and in a very professional manner?
No, but the answer to your question is I don't do them at the same time. I I learned playing the piano, and I play not so much, but I play sufficiently. I can read music, I can tell you that much. So Western music is written down, not Hindustani music. Hindustani music is not written. Hindustani music you only learn by training yourself. and you play, say, suppose you play a rag. Rag has a definite notes to it. So you play 1,000 times or 10,000 times, then only you get perfection. In Western music, you can read the music and play. Maybe you play ordinarily or whatever. So similarly, I was very fascinated by the sound of a saxophone right from my childhood. So then I sort of met a teacher. He was very good to me. Now he's a retired army officer. So he taught me the basics. So now I have to practice on my own. Similarly, I am playing a little bit of bansuri. So yes, I can play the notes now. I just started maybe three sittings I've had. But what really excites me is that music only has 7 notes. Sa re ga ma pa dha ni sa. So in this, the entire music is played. So I used to always be very fascinated as to how you can manage to do between these just 7 notes. So apart from music, I play a little bit of golf. I'm not very good at it, but I manage. Then what else I used to do? I was a very keen rider. I used to ride horses.
Horse riding.
Yes, yeah. I used to ride horses, and I was a sports person right from the beginning. I used to do athletics. I boxed in my college, and I boxed right up to the university level. I boxed both flyweight and bantamweight. And I did athletics, as I told you. So, and that's what even in law I found that there is something I can do even at this age. I can do a little bit of the same passion but in a different way. For example, horses. I am now lawyer for a sports association, Rajasthan Sports Association, and I am appearing for them in Delhi High Court in a very famous case which is going on against the Equestrian Federation of India. I also filed a case in Delhi High Court in my own name when I found that a boxer, Sarita Devi, she was not given her rightful medal in Asian Games, which were held in South Korea. I filed a petition because she was banned for 2 years and I felt very bad. And I felt this is very grave injustice. And nothing was being done. So I filed a petition in Delhi High Court. And thereafter, it transpired to the sports ministry that they could have filed an appeal before what is known as CAS. That is the arbitration for sports internationally. And it's known as CAS, Court for Arbitration for Sports in Lausanne, in Switzerland. So that case I did. And basically, my interests have even survived in doing some service to these sports in the sports arena. Then what else should I tell you? I do a little bit of gardening also. I have a small farm. I grow vegetables, and then when I have more excess of vegetables, then I go and give them to the blind.
You look
school.
so happy while you are talking about your garden.
I give them to the blind school, or I give them to the gurdwaras, and of course I also consume some of that.
Knowing so many dimensions of your life, I am compelled to ask a question.
Yeah, please do.
If you were not a lawyer, what you would be?
No, I think, as I told you, I was a reluctant lawyer.
Yes.
And my background, I told you, was service background. My father was a police officer. I don't know what I could have done. I can't tell you that today. But yes, being in this profession has helped me to use my time in various activities. Because apart from doing cases in the court, spending time, the whole week almost goes there. Every Sunday, people think Sunday is a holiday, but for lawyers, Sunday is not a holiday. We start working in the afternoon and then Monday, Tuesday, Wednesday, Thursday.
We have cases.
Yes, up to Friday. Then we have Saturday, Friday afternoon onwards on Friday, and it's not definite all the time. It's changing. So you have to manage yourself. If you manage, you can do little bit of everything. But I mean, you can say that I'm a rolling stone and I gather no mass.
There's so many things I want to ask you, but we have little time. But certainly there is one thing I have been resisting, but I'll ask. And that is, at the time of our independence, we had the Constituent Assembly. Most of the parliamentarians were lawyers. Rather, many of them were lawyers. And today the number of lawyers in the parliament is reducing every day. Lawyers, I feel, certainly make good parliamentarians because they are aware of the law. They can contribute more in the lawmaking process. Would you like to be a parliamentarian yourself?
No, I'll answer that question very simply. See, I want to stay away from politics.
Uh-huh.
I don't like to indulge in politics because politics is something which either it is up your stream or not. See, as you know, that I have been Vice President of the Supreme Court Bar.
Yes.
Now, becoming a Vice President of Supreme Court Bar is not an easy thing. I fought elections even for the post of President. I did not succeed. But I was always a part of the bar.
Sir, I voted for you.
Yeah, thank you very much. I always recommend to everybody, all interns, all juniors, that they must always keep themselves associated with the Bar Association and always, do work which a Bar Association. And incidentally, sitting president of the Advocates on Record Association was my junior.
Uh-huh.
Vipin Nair.
Oh yes, he's the president of the...
He is the president.
Scora.
Scora. And he was my junior.
I know that. And Vipin is doing a good job.
A very good job. I think and we have a small group of my juniors where we meet once in a while. And
recently...
each one of them is doing very well.
Recently, 2 lawyers were summoned by the ED and Scora wrote a very strong letter on that issue.
I think...
And those summons have been withdrawn since then.
Yes, but the fact is that they issue a summon to a lawyer for an opinion that he gave to a client. I am absolutely shocked that
we all are.
Somebody gave them this advice. Because ED comprises of what? They are investigating agency. They have a certain complaint before them. Somebody has done some illegality. Now, in that investigation, they thought it is fit that they should issue a summon to the advocate who gave the opinion. Don't they know the basics of law? They are well advised. And yet they have to do this. It is unbelievable. And look, the fact that they withdrew it immediately itself shows that they were trying to do something which they can't do.
Yes. So, we have had an insight into a life of a Supreme Court lawyer who has been there for 5 decades and whose life is an inspiration for everyone. Sir, before we close, I want you to give a message to the young lawyers, what they should do in order to enhance the grace of the profession, contribute to the nation, and contribute to the evolution of law.
I think the only message I can give is that to the young lawyers is that they should work hard. And as I said, always they should maintain very good ethical standards. A lot is expected from lawyers.
Yes.
We earn our livelihood, as I said. I earn my livelihood by being a lawyer. But law is still not a business. It is something, so many things you have to do on your own. See all the concept of public interest litigation. How did it evolve? It evolved because the lawyers came forward. In fact, you just said that the Constituent Assembly comprised of lawyers. So the lawyers have always been on the forefront. And it is for the lawyers to take care of all that is happening in the society today. When I say all, it doesn't really mean all. I mean most of the things which a general public, a person from normal walk of life is not able to do. You have to take it up and you have to confront the courts with it and assist the courts in coming to a proper judgment in law. That's all. So I think maintaining ethical standards is most important. And secondly, work hard. And the only thing I find today very disheartening is all young lawyers you meet, again I'm saying all, I don't mean each and everyone, I mean mostly I come across, they are joining the profession to earn more money. I am very sorry. You know, this earning extra money and earning too much of money is a very new phenomena. For example, Palkiwala, nobody knew what his fees was, and now we have newspapers coming, this is the fees that the seniors charge, etc., etc. We have gone to that level. Mr. Jethmalani always charged huge fees, but he did so much of work free. And at that time, people were more concerned about their legal acumen, about doing their cases. And of course, let me be very frank, the entire the Constitution, if you see the Constitution from 1950 to 2025, if you break it up into 10 years each, it is the contribution of the lawyers that has evolved the Constitution. The judges have contributed, yes, it is their judgment, but who assisted them? It is the lawyers. So therefore, I think you are in a profession where you have to work very hard, and of course money will come. And one of my very good friends, senior advocate and then became a judge of the Supreme Court, he always said, don't run after money, it will come. It will come itself, but you must work hard and prove yourself. Thank you.
It was wonderful talking to Mr. Dutta, and I really don't want to stop here, but there's limited time. I've always enjoyed talking to Mr. Dutta, and here is the message for not only the youngsters, but all of us. Lawyering is not a profession. Advocacy is not making money. It's not a business. It's a commitment, and here you have an insight into 5 decades of a lawyer who has been committed to the profession. With this, I close this. Thank you very much for joining us. Thank you very much. Jai Hind.
Thank you.